Welcome to another episode of the Ask Amity Show. My name is Edmund.
I'm Jennifer.
And I'm Cindy.
And for today's topic, we're going to talk about why a will is not enough to avoid probate court here in California. So for those of you who don't know what probate court is a process where families would have to go through if one of their loved ones pass away. This is a legal process where a court will determine where that loved one's assets would go, who receives them, how they receive them, and things like that. And a lot of times we get this question of, why isn't a will enough to avoid probate? It's the law in California, unfortunately, that even if you have a will, even if you've laid out exactly how you want your assets to be distributed, California still requires you to go through the entire formal probate process in most cases. So, Cindy, why is a will not enough to avoid probate?
So, a will is not enough to avoid probate in California for a few reasons. One of the issues is formalities. So, a will is not it's not required to notarize. You don't have to notarize the will. And the only requirement that a will needs is that it's witnessed by at least two people who are not taking anything from the will. So two disinterested witnesses. So it's not quite the level of formality that trust requires, which does avoid probate, and which Jennifer can speak about a little bit more later. But so that's one of the reasons why it's just the lack of formality that a will requires to have to make a will. One of the other reasons is also has to do with formality, is that when you create a will, you're essentially listing your intentions. You're stating your intentions in writing, but you're not actually taking any steps towards those intentions. You're not transferring any titles to any real property when you make a will. You're not listing your will as the beneficiary. You actually can't list the will as a beneficiary to any of your assets, whether it's bank accounts or savings accounts. So none of those intentions that you have are actually being, you're not taking any steps to further those intentions other than listing out in the will. So those are some of the reasons why just a will is just not enough to avoid probate.
Yeah, but in the alternative, if you do have a living trust, that does avoid probate. And so what Cindy was speaking of on the formality issues, a living trust is a lot more formal. It requires the signatures be notarized. And in order for a living trust to sufficiently be able to transfer those assets out without probate, we would actually name the living trust as a beneficiary on your bank accounts, your investment accounts, your real properties would be transferred and recorded at the county recorder's office with the living trust as basically the owner on title of the property. And so those are the formalities that take place to further show that this living trust has more binding and it's more enforceable, where it can avoid probate just based on your living trust, a original or certified copy of your death certificate. Then the trustee that's named in the living trust can just go ahead and transfer those assets out to the beneficiaries listed in the living trust without having to go through probate, without spending the time and waiting for the court to decide who your trustees or who your beneficiaries are. And so it's a lot more simple, less costly, and time saving.
All right, I think that's it for this episode. If you have any other estate planning related questions for us, leave it in the comments below, and we'll do our best to answer them for you on our next episode. We'll see you next time.